Уважаемые коллеги, я думаю, будем уже начинать. Дмитрий Валерьевич Вольвач задержался на другом мероприятии, он сейчас придет.
Distinguished colleagues, I think we are about to start.
Уважаемые участники,
Dear
гости нашей сессии, для начала хотелось бы всех поблагодарить за особый интерес, проявленный к нашей сессии. Действительно, очень большой интерес был проявлен. Уверен, что у нас сегодня состоится очень откровенная, интересная дискуссия, ведь у нас
and interesting discussion, because in the Presidium we have lawyers representing member states, Eurasian Court, Eurasian Economic Commission, the main architects of our legal system. Law of EAEU is uniting us all, so I would like that our today's discussion is conducted under the motto EAEU law is our treasure. housekeeping announcement, each presentation 7 minutes, and Q&A session 2 minutes per speaker. And I would like to kindly ask all of you to stick to the agenda and to the timing. Hello. I would like to introduce the chairperson of the EAEU court, Mr. Dronov, Minister of Justice of the Republic of Belarus, Mr. Evgeny Kovalenko, Judge of the Constitutional Court of the Republic of Kazakhstan, Ayjan Zhatkanbayeva, Judge of the EAEU Court, Askar Kishkembaev, Deputy Head of Justice, Deputy Minister of Justice of Kyrgyzstan, Saira Izakova, Head of the main department of the International Legal Cooperation of the Prosecutors General Office of the Russian Federation, Mr. Vinogradov, Head of the Secretariat of the All Belarusian National Assembly and the Chairperson of the Belarusian National Union of Lawyers, Valery Mitskevich, and Director of the Legal Department of the Eurasian Economic Commission, Ms. Truhanovich, Ms. Short Truhanovich. So let's start, and our first speaker is Alexei Dronov. So this jubilee year for the court and for the EAEU, we have been talking a lot that the court of the Eurasian Economic Union is a well-established organ. For the dozens of years, the court is cementing the integration legislation. It works with the Eurasian Economic Commission, with the national legal systems. Alexei, what is the main mission of the court and the consultative rulings of the court, what kind of effect they have? Thank you, distinguished colleagues and friends, for your interest towards our session. I would like to admit that we have a club of the friends of the EAEU court. Answering your question, I can just say that originally it was a hypothesis. After the first months of my work as a chairperson of the court, but then it got proven. And I would say that the court is now in the second phase of its development that is described by a number of peculiarities. So without changing any basic parameters that are spelled out in the agreement about the competences and the composition of the court that were mentioned in the statute and in the agreement. But we have already an established practice of our court. When comparing the activities of our court and our union with other judicial organs, I would like to say that we are not lagging behind. EAEU court has worked a lot. We considered 100 cases over 10 years. We are a young court, and this is good, I think. I would like to highly appreciate our colleagues who started all this work. They created the foundation. Because, you know, the agreement that was signed, it is not establishing the court by default, so it was all done by people. By the first composition of the court, I would like to highly acknowledge the work of our colleagues. It does not mean that this practice practice of our court is cast in stone. No, of course, we need to be very responsible towards our judicial actions. We should bear in mind that the court needs to be identical. If we need to adjust some of the legal standings and positions, we should do this in the spirit of the Eurasian integration based on the law. Second important thing is that when people started working, they didn't have any practice. The main source of this judicial practice are member states and the Eurasian Economic Commission. Many questions or matters that we had from the very beginning. Maybe member states were not ready to address these issues or matters that occurred at the very beginning. But after 10 years is not just a beautiful number, but it's quite a period. We have gained experience, we can analyze this experience, and based on this experience we can develop our institutions and mechanisms further on. Eurasian Economic Commission, of course, plays a leading role because it performs the lawmaking function, the law enforcement function, but Eurasian Economic Commission is part of the political process. It performs supranational role. It's a supranational organ. It elaborates certain stances and positions, but all these stances and positions rest on the law of the Eurasian Economic Union. And this should be done in the interests of political reasonability and should be compliant with the provisions of our agreement. We should not be going beyond the law. Of course, we should not be having these double standards. And now a few words about the role of the court. The court is beyond the political process. It's outside the political process. We perform our function as an independent judicial organ. We work based on law. Any other attempts to give us some other tasks, they will not, they will be harmful, I would say, because we do see in our statute, in our agreement, a careful position of the member states. They were very careful when preparing all these documents and articles of association. The member states should have trust to the court, to all the institutions. And our main purpose, our main task is to create this trust by our own activities and to promote the idea of the rule of law. And this idea is promoted under the conditions when the external world is rejecting the UN statute, the international rule, as a regulatory function. For us, it's not just a regulatory function to regulate relations inside EAEU. It's approval of our common values, both inside and outside, because the strategy and the agreement says that our main purpose to be a nucleus, to be an engine of the Eurasian integration project. So there are a lot of questions about the distribution of competences and problem of policies. So the policies should be well coordinated, unified, and we as a court should be doing this. Based on law, we should address the issues that sometimes were not addressed by the governments. either by chance or deliberately. I can talk a lot about the court and EAEU. Unfortunately, I don't have any more time. It's a pity because I'm ready to speak and speak. Maybe our moderator would ask something so that I can speak more. Well, thank you, Alexei. Thank you for mentioning the trust. So, what is your opinion about the consultative rulings? Well, consultative rulings. So, you should not believe in what you see, actually. People say that these consultative rulings are not legally binding, are kind of recommendations, but it's not the case. And we have a principle of uniformity. We have 5 jurisdictions. We have enforcement in 5 member states, not only in the court, not only in the supranational level. So these advisory opinions or rulings do matter. There might be questions about ambiguity or some gaps. The first thing that comes to your mind and to the member states, well, I want to develop a federal program, but I don't know whether it will be in line with some of the provisions of the agreement. They come to the court, they request our opinion. And the court, when preparing this advisory opinion, they are not resolving the dispute. We're just explaining the provisions of the agreement. It's quite a difficult procedure. We scrutinize the agreement from different lenses and angles. There might be different viewpoints. And we in the court, we do this work. We discuss this. We run a number of iterations. And then we have an opinion, a ruling, this advisory opinion. It's a very creative process, I would say, on the one hand, but it's a very powerful tool to reduce ambiguity and closing the gaps. And we haven't yet implemented the full potential of all these advisory opinions. And one of the colleagues of ours suggested to include the courts into the list of authorized bodies, and if there are any questions, we can request other courts, their opinions and rulings. And this might give a very good effect without using this complex structure of political, reconciliation.
Thank you very much, but the last question, we would like to hear your opinion. We are talking about the future. If you had an opportunity to envisage a mechanism which does not exist so far to increase the significance of law, what mechanism would you suggest? What mechanism can I suggest? I have principles based on which we have to act. First of all, we have to follow our needs, and we have to develop national programs based on our obligations. And let's not waste time of each other. And when we talk about Russian Federation, Part 4 of the 4th article of the Constitution. If we do not create the awareness in this field, we may develop any standards, but if there will not be legal specialists which will take into consideration the law within the union, it will be a difficult system which will be not possible to implement. We have to cooperate, and the court has a function of expert and analytical body. Of course, we all need hear opinion from other colleagues from academia and from the economic community. The unique place is taken by law in integrational processes, and international law is implemented. When we talk about sectorial elements, Brussels system, or for example, air law, there was a case recently. Another aspect, the correlation of regional standards for CIS. And we have certain rules developed, and we have national legislation. Our solutions on the human rights, they reflect our constitution. Therefore, highly qualified specialists are needed to drive this system. Thank you, thank you. Now it's time to give applauses. Thank you. Evgeny, today we see, based on the scale of our forum, that Belarus, in the year of its chairmanship, is very responsible. What are the main priorities of Belarus that it sees in legal field? Thank you, dear colleagues. First of all, answering to this difficult question, it's easy to answer for legal officials. It's following legal mechanisms. And this is the main priority within the framework of EAEU. If we talk about EAEU law, we remember the words about the Alice in Wonderland. The time has come when, in order to stay, you have to run, and if you want to move forward, you have to run twice faster. When we talk about economic processes of EAEU, well, it fits well to this kind of proverb, because we talk about supranational level. However, certain sectors have not been covered by national regulations, and of course here the issue of harmonization of national legislation is very topical, because understanding the joint economic policy is very important within the framework of EAEU. When we remember how the agreement on the union was signed in 2014, the head of state, Mr. Lukashenko, said, we are signing this international agreement, but we are continuing working on it, and we are working on implementing amendments, and we have prepared 3 protocols so far. We are working on the 4th one, and we understand that the first half of work is establishment of such right, and the second part is harmonization of it in terms of implementation. And here we see the role of the union bodies and also the role of the court, the tools which the court has, and when we talk about advisory opinions, it can be widely used. And when we talk about other governmental bodies, it's important to implement monitoring of implementation in order to give the assessment of the actual situation. Without this, we cannot move forward. Thank you very much. Thank you. We know that as of today, from the union's bodies and member states, efforts are put in order to protect the private persons and citizens. In this regard, we would like to know, in your opinion, how can we increase the awareness about opportunities presented by the union's law, and how to protect those rights. Well, popularization of ideology of our union is in the field of awareness raising, legal awareness raising. And in 2023, the concept was agreed at the level of the head of state, and this concept has to be reflected at the supranational level. And EAEU is a kind of brand, and it can be reflected at media space, in educational programs, and our work format may be different. We have to establish the mindset. It's not only talking about the abbreviations, work group protocol, EAEU, but it is rather what are the principles upon which the trade movement, capital movement, intellectual property issues are being regulated. And here we talk about beyond borders of products, goods. For example, if we talk about CIS for 2027, we have announced the year of legal awareness raising year. And I think that similar initiatives can be implemented in this regard. And, for example, organizations can also participate. Valery represents such organization. We are glad to remember that 1 year ago you presented your presentation at Peter's Forum, which took place in St. Petersburg, and we are glad to see you here. Thank you. Dear Saira Semirbekovna, the floor is yours. You know, the legal structure of the union may interact with national legal systems in different ways. For example, some systems are not introduced the same way as in others. So how the law influences national legislation, and how is it felt by citizens of your country and businesses? Thank you, dear participants. Kyrgyz Republic, we joined EAEU in 2015, and As of today, 10 years passed since then. Of course, it has influenced our legislations. We reviewed it in terms of harmonizations and in aligning our norms with EAEU law. How this process is implemented. In general, we have to point out that we adopt our legislation for the rules of EAEU, which provides opportunity to our entrepreneurs to increase export volumes. For example, our export volume is more than $3 billion US dollars. It increased by 43%, and to EU countries, exports grew by 10%. And the demand for Kyrgyz products has increased, and the process of integration and adaptation to the EAEU law, it's a constant process taking place on a regular basis. The last reform is taking place currently in March of this year by the order of our president. He signed an order on de-bureaucracy. It's an instrument towards integration to EAEU law to eliminate barriers and make enabling environment for business. For example, some of the initiatives, the Parliament is analyzing amendments in our court that the amendments can be implemented no more than once in a year in order to build a stable structure. And we initiate amendments, for example, in the civil law and administrative law procedures. There is amendment that such cases could be dealt online, in online basis. And initiative on liquidation procedures to simplify it, especially when we talk about organizations which are not in operation, but they cannot shut down their facilities because it is difficult in legal terms. We try to make legislation easy, simple to understand. It should be enabling to develop business with EAEU countries. Thank you, Saira Sarimbekovna. Is there other question? Kyrgyz Republic often mentions that we have to think about applying to the Court of the Union on different issues. We see the trend. I would like to hear your opinion. How is it considered in your country? Is it an assistant in solving issues, or is it an extreme measure?
Well, we consider EAEU court as a reliable tool to resolve potential disputes, as a tool to find answers to certain questions and legal uncertainties. We use the court for the protection of our interests and avoiding this uncertainty within our integration space. I would like just to give one example. At the beginning of the year, Kyrgyz Republic, the Ministry of Transportation and Roads have applied to the court to explain the regulation of access to the services of railway transportation. The main idea of this application was that certain tariffs were set, and these tariffs were higher if it is transit, goods in transit or not. So additional coefficients or indices were applied. And the Court of EAEU on April 24 provided explanations. Based on its explanation, it was confirmed that there is a principle of non-discrimination and equal access and non-discriminatory approach to all types of transportation. So this application to the court, we consider it as a tool to protect our interests, as a tool of ensuring fairness in EU and equality between the partners. So we consider the court as an institutional partner in this respect. Thank you, Sarah. It's good that we heard that Kyrgyzstan considers the court as a reliable partner in dispute resolution. Our next speaker is Mikhail Vinogradov. Prosecutor's General Office of the Russian Federation is a unique organ that has authority to apply to the court. It coordinates the activities of the governmental bodies and agencies of the Russian Federation. It represents the interests of such governmental bodies. In this respect, it would be good to hear your opinion about the law of EAEU and the procedural mechanisms that exist, and what is your opinion about that? Thank you, distinguished colleagues and participants. Well, every time when we have such kind of events, want to say something new, positive and forward-looking, but when preparing for this event, I decided to analyze the current state of affairs. What is the interaction between the court and the member states, the competent authorities of the member states? And to my satisfaction, I would like to admit that our cooperation and interaction is very good and constructive. We, as a Prosecutor General's office, try to help the court in its work. We cooperate in three main domains. The first one is that we respond to your applications, to your device. We share our opinions of the Prosecutor's General Office, as well as representing the interests of other governmental agencies of Russia that can contribute to the consideration of the case, so that the court feels comfortable in analyzing the respective materials, analyzing the information and the inputs. And this is done not only by your request, but also we do this on our own initiative. Whether we want to share our opinion, for example, and help you in exercising justice. And I will explain later on why it is so important for us. So the court is exercising its authority under the statute. You can request any expert opinion. And I would like to mention that in Russia, we respond to each and every case, to each and every instance when we need. Last year, it was the first case when we acted as an interested party, as a stakeholder. I don't want to dwell about this now, because this experience, this case, has shown that the agreement is really diverse, it's large scale, and it is not used to its full potential so far. After a number of years, when we gain certain experience, when we have certain practice, we will see how it works. It will be reflected in the decisions of the court. It is a kind of unusual mechanism for an international court, when the member states can speak up, can act if the government or the member state believes that it touches upon its lawful interests. Another important cooperation domain is enforcement. Enforcement is the quintessence of judicial operations of any court. And this enforcement is a two-sided street. It is not up to the court how the ruling is implemented and enforced. And of course, there's another stream. It's like a willingness of the EEC or the member state to enforce the decisions. Today we were speaking about the advisory rulings and the advisory opinions of the court, and our office has a unique status because we have really a wide range of tools available compared to other governmental agencies. That's why we take measures in order to enforce the solutions and the court rulings on different disputes. We also try to enforce the advisory opinions as well, regardless of the fact that they serve as recommendations and are not legally binding. For example, in March 2024, there was an advisory opinion about explanations on the employment relations and rights. The Russian Ministry of Labor rejected one of the court employees to assign a pension. So the case was considered by the court, and the advisory opinion was shared. And after that, the prosecutors general analyzed this case. We analyzed the proceedings of other Russian courts, and then the rulings of the courts were cancelled, and we sent it back to the first instance court, and this court of first instance of original jurisdiction had to revise its ruling to consider the work experience of this person in the court and to assign a pension to him. Another example is a ruling, a quite recent ruling of the court, BG Tools MSE, applied to the court. As a result of the case consideration, the court decided to take response measures on behalf of the prosecutor's office. The prosecutor's office issued a letter to check whether the rules and norms were properly applied in calculating the customs value according to the EAEU rules. It was addressed to the transportation companies of all the member states, and it was legally binding for all the member states and companies. So this is another example. So I have more, but unfortunately my time is up. Thank you. I think the majority of people in this room would agree that enforcement is one of the important pillars. And maybe most of you know that you personally were the founding father of the EAEU agreement and the court's statute. What is your expert opinion about the prospects of institutional development in EAEU? Well, it's a difficult question for me because on the one hand, I am in favor of stability, stability of the agreement, stability of the legal issues in EAEU. But I think that we haven't yet achieved the full steam. In terms of the court's work, we still have a lot of room for improvement. And after 9 or 10 years of court's operation, we analyzed the results of this work. We do see the evolution of the court and its operations. For example, I gave you a vivid example of the advisory opinion that was taken into account and implemented. And the advisory opinions of the EAEU court are not considered circumstances to retrial the case. Me, as a specialist in this field, I have a question. Have we already approached the point when it can be qualified as a new circumstance or not? Should it be taken into account or not? What can be done in terms of lawmaking in member states? Do we need somehow adjust and update the agreement of the Union? But it's again an issue of enforcement. Every time there's a question about institutional requests and queries, I would agree that maybe we need to work further. It's an evolutionary approach, not revolutionary one. And Eurasian Economic Commission does some work in order to close the gaps in implementation and exercising the rights of certain persons to apply to the court. So these 10 years of experience have shown where we're going and what should be done. Well, as I mentioned, I'm in favor of stability. That's why maybe we should not invent something new, but step by step we're moving forward. We're developing the competences of the court and certain institutions.
Dear Askar Bulatovich, the results of the analysis of the legal practice looks very interesting in terms of matters by which the court is applied, and they take preliminary matters. And there are certain comprehensive matters for for provision, competition, internal policies, etc. And there are many matters which are being accumulated. We would like to hear your competent opinion, and I'm sure that the audience will be happy to hear the recent practices regarding covering the internal domestic markets. Thank you very much for the interest in our session on court procedures. I would like to tell you that recently the trend is regarding the shift in the categories of from customs issues and disputes towards the competitiveness issues. In particular, here the advisory opinions which are based on the need of law enforcement in the countries, and here we talk about legal commission and harmonized law enforcement in terms of competition. And in my opinion, we have faced the situation when there is a separation of these issues. We have explained to the legal commission regarding the procurement issues in order for Commission to understand fully the peculiarities of the issues. And, for example, if higher prices were identified, certain ideas had to be explained, and the model of behavior is important. For example, when we talk about collisions between national legislations and legislation of EAEU, how can we handle these disputes? We have to understand that in the Republic of Kazakhstan, the court bodies have experienced difficulties in interpretation of competency of antitrust, anti-regular organizations. And the law explained, the court explained that by interpreting the competences, we have to have a comprehensive understanding and to qualify as a violation if the final price is defined not by supplier but by the client, and the supplier shouldn't be punished in this regard. And the Supreme Court of Kazakhstan has suspended the procedures on its case, and it is a very topical issue, and the legal positions of the Eurasian Economic Union have been reflected at the decision of court after the conclusion have been set. So the positions of the EAEU court were taken as the guiding. There were other cases, and when we talk about Kazakhstan or Russian Federation or Belarus, when national legislations have to be amended based on the position of the court of EAEU. I'm glad that we are holding discussion here, and we understand that the potential of the legal position of court is very important, and their potential was not fully implemented recently. However, due to measures regarding their advisory opinions, despite the fact that they are kind of recommendative, yet they help to overcome at certain stage collisions and gaps in the law of the Eurasian Economic Union. Here I would like to talk as an expert, not as a judge, about the development of our integration. We are all supporters of Eurasian integration, yet I am a little bit concerned that sometimes doing one step forward, we make 2 steps backwards due to facing barriers. And some countries do it consciously. And certain national experts, whether they correlated with the law of the Union or not, the countries, by signing this document, agreed to follow all the rules. Yet, from time to time, we can face certain violations of these practices. And the court sometimes have to be involved in the issues. The last example is visa implementation, visa practices implementation by one country towards others. It's a barrier towards the free movement of people and goods. It's not a good example of correlation of obligations taken by one country, one party regarding the others. So it looks like some countries follow the rules and others don't. I present here my speech as a speaker, and I would like to see more higher attention to be paid by the Eurasian Commission to avoid bad practices. Yes, we can talk a lot today, and if similar issues would arise, the Eurasian Economic Union's court is ready to provide interpretation based on the goals and objectives of the integration, based on the signed documents. Thank you.
Оскар Булатович, позвольте еще один
маленький вопрос. One small question. We are sure that everything is being followed and the decisions of the Constitutional Court or advisory opinion decisions to be implemented. And when we talk about the examples, would you like to share some examples of implementation of court decisions? Well, it's an issue not only about the court, but all interested parties, expert parties. For example, when we talk about national level, the rights to implement the practices for solving disputes. It's not enough just to solve the dispute. The decision of court has to be implemented. And I believe that we are not fully implementing certain decisions. And if it is made on purpose, well, it doesn't matter. I believe that so far there are no new mechanisms to implement the court decisions. We have to introduce perhaps new tools and mechanisms. However, I don't see systematic violations. So if there is certain disease, we have to look at all symptoms. And I believe that we will jointly solve the issues within the Commission platform and within the court platform. Thank you. Yes, Oskar Bulatovich have voiced the barrier problem. It is one of the priority issues within the framework of EAEU law. I would like to provide the word to Dmitry Valerievich. Since creation of EAEU, the countries set ambitious goals to construct a unified domestic market, what place national law enforcement takes, and what details are lacking, details of the puzzle are lacking to finalize the process of construction, this unified space. Thank you. First of all, it's a great pleasure for me that during the forum we intensify the topics regarding law and legislation and court practices in order to understand the matters of international law, which were lacking attention so far, and we started to implement it in our culture of conducting forums, and national bodies they have better understanding, and certain representatives of governmental bodies, they have better understanding of the consequences which happen if there are barriers, if there are contradictions in national law or law of the EAEU, when the court has to be involved, and our EAEU court is unique in terms of its functionality, in terms of its employees. We have to value it highly, and if we have a need to apply to the court institution when dealing with the disputes, it is highly important to do it for better understanding, to better understand the legal basis, legal reality, which is reflected at the economies of our country, and it was voiced in this forum. It influences the constitutional rights of the member states, and when we talk about barriers, of course, you are absolutely right. It is an endless issue, because it is within the principles of our union, free movement of goods, capitals, and labor force. And since we live not in imaginary world, not in computer reality. We live in a real world. So we have built one of the best integrational unions in the world. Maybe for some institutions we are not part of them, but in terms of economical growth indicators and global transformation parameters, regionalization and other paradigms, multipolarity, sanctional aggression which takes place to the countries of the members of EAEU. Well, we achieve good results, and there is no ideal picture. There is always a tendency to attain good results. And if we talk about removing barriers, we have learned how to take responsible decisions at the national level and to respect Commission's opinions if there are certain limitations for trade, for free movement of goods. We have to take it into consideration.
With recent number of years, I have checked the statistics of limitations introduced by the countries. It's a global tendency of regionalization and protection of domestic markets. Sometimes these decisions are impulsive, but sometimes they're quite objective. And so far, we have certain statistics of restrictions and limitations introduced. It says that all member states of EAEU has increased the number of restrictions in trade to protect their domestic manufacturers. In 2024, compared to 2021, we had 30 trade restrictions compared to 7. We have 33 measures determined inside EAEU. Russian Federation introduced 4 measures, Armenia 4 restrictions, out of which 4 bans, Kyrgyz Republic 6 limitations, other countries as well. And this is not always the legal issue where, politics and law overlap. Then we need to analyze whether this restriction or limitation is in line with Article 29 of the agreement, because we have Article 29, which reads that there is a list of constitutional values like life, health, defense, protection of the environment, and in some exceptional cases we can, the member states can introduce limitations and restrictions. But we need to strike a balance, This balance exists in any real world or real economy. And sometimes it even reaches the courts, and we have court rulings on that. So I wouldn't just make conclusions here. I'm just giving you the numbers. Yes, we have an increase in the number of country limitations and restrictions. Each country introducing this restriction, they claim that they act in line with Article 29 of the EAEU agreement that allows for doing so. That allow introducing these limitations and sometimes neglecting the barrier-free environment. I would say that we need to have a closer look at this. Maybe to think more, to have less emotions, and be more maybe professional, to take informed decisions. Because I'm sure that a number of these decisions have objective grounds and justifications, and they are adopted fully in line with the EAEU legislation. But some limitations and restrictions, if we scrutinize them, might be maybe recognized unjustified, not fully in line with Article 29 of the Union. I cannot say which of them, of course, but there is such a procedure. So I think that our court has a lot of interesting cases to solve, and this will lead to stronger legal discipline, respect of law in EAEU. Not only we have trade barriers and freedom of movement of goods and services, as colleagues mentioned, in different spheres of national regulation, countries might employ different mechanisms that can be considered as limitations or restrictions. Migration sector. Our agreement does not apply to the migration sector. Migration is fully a national domain. We are not speaking about visa regimes, of course. But digitalization of the migration records, it's a normal process. It happens in many countries. If you are speaking about the Russian Federation, I can assure you that we will build the process in such a way that all these records and monitoring will be smooth in the near future. It will be well done, because if we are taking into account the records, it means that we are protecting the rights of migrant workers if they work in this or that country. I'm sure that the measures that we take, we need just to fine-tune the system. And these measures will improve the rights of the workers when they sign a labor contract in the other country. Usually they are underprotected, they are vulnerable, and the migrant workers' rights might be violated. So we believe that we do our best in order to improve our labor market, have it equal and accessible to people, protecting their rights. Thank you. Dmitry, you mentioned about one-sided measures that the countries can introduce under Article 29. Actually, the court considered this issue under its advisory opinion about the free movement of goods. They considered whether these measures can be taken collectively or individually. And the court confirmed that countries can have such individual measures, but the court also drew attention to the necessity to strike a balance between integration and the domestic interests of countries. So, what is your opinion? How can we strike this balance? And are the existing mechanisms sufficient enough? Well, in this equation, we have another variable. Besides these restrictive measures, we have stimulating measures. These are not a number of measures that are aimed at supporting countries and certain sectors if a certain threat occurs. I would like to emphasize that despite the increase in the number of one-sided measures, I wouldn't say that this is a negative phenomenon. Maybe it's objective reality. Maybe this is the response of the EAEU member states to what is happening in the world. They were quite adequate. There were no breakups of value chains or supply chains or kind of isolation of certain sectors. No, this was not the case. Recent years increased the level of cooperation. They improved the linkages and connectivity between our countries. I would call upon regulatory bodies in transportation sector and other financial sectors. Please bear in mind that the agreement allows us not only to restrict, but also to facilitate, to support. So there are other ways of providing support to industry or agriculture if some additional risks arise. For example, we introduced a mechanism of additional financing to production cooperations and collaborations. This again testifies that we are aimed at cementing and gluing our market together rather than separating. So I think that we will survive these turbulent times. So, legal department of the Eurasian Economic Commission is staff, I would say, headquarters of the Eurasian regulatory body. You combine lawmaking and law enforcement functions. It is interesting to learn your opinion about the development of law in the Union. What are the tendencies in the development of legislation and law of the Eurasian Economic Union? Well, thank you. I would like to speak about trends and tendencies. I will be speaking more from the instrumental viewpoint because we are building our Eurasian Economic Union. It is important to understand where we are and what is the current state of play. I believe that our union is a stove because in ancient times they started to build a house around the stove. So they built a stove first and then built a house. The same is in EAEU. We start with the integration. It's the main mantelpiece, the main stove of the house. We start with this integration. We have the court. We make decisions. I would use this metaphor for you to better understand the trends that I would like to outline. As a head of the legal department, I would like to say when we did codification, when we prepared the single international agreement on EAEU, it was a very exciting process to do this properly. And we managed to do so, and we can be proud of making up this agreement. And now we have anti-codification process. We have 90 agreements in our union, international agreements. And again, we have this full diversity and variety, because at the top of our pyramid, we have EAEU agreement. It's quite clear all international agreements should be in line with this. But when we have these 90 other kinds of agreements, there might be contradictions in between of them, especially in healthcare market, pharmaceutical market, in finance sector. And it's a trend that our member states are signing international agreements. I wouldn't say that it is good or bad. It's good that we don't introduce amendments into our main agreement, EAEU agreement, because, you know, sometimes you might make certain mistakes. But the main disadvantage in this international agreements under our union is that the countries maybe do not fully trust the Commission. They don't trust the EEC, and they apply this direct regulation, and international agreements cease being a classical source of international law. They don't contain norms and principles, they contain rules. And, you know, when you prepare this international agreement, when you don't give this right to the Commission by signing this agreement, then you can't change it, you can't respond in a timely manner, you know. I mean the requirements to products, trademarks, etc.
In comparison to making amendments to the main international agreement, for example, certain amendments can be disputed at the court. However, there are disadvantages as well. For example, what happens? The state can apply to the court. And what happens if the agreement is agreed to be not in line with international law? So, in terms of regulating international agreements, it's trend. Okay, I have 3 minutes. I will speak fast now. The second tendency, and the third one, the slowdown of lawmaking, and please don't worry, it's a normal stage, and all cycles go through establishment, expansion, tracing challenges, addressing challenges, but the quantity of legislative acts decrease, and I asked artificial intelligence, asked GPT chat, how do you analyze these tendencies? And it answered, it's a phase of stability, and on 2021, it was a good year, and I agree with artificial intelligence GPT. We had a good push from the expansion, and the trends in this picture of slowdown, we work on development of declaration. There are lots of challenges, but I hope that there will be advantages. Another tendency, the COVID year and 2022 phase provided the demand for the act of the smooth law, of mild law, and soft law. And recommendations, they play a certain role. And each time when we hear that there were recommendations, we think that, well, they have not reached agreement. And I asked GPT chat whether these recommendations in the Russian Federation, whether are they being used in the regulatory fields. And yes, of course, the logic of recommendations is not good. It's better to take the recommendations and implement them within the framework of our documents and reformat them into the decision acts. So recommendation, the period for its implementation of 1-2 years is enough, and then it can be transferred into the act level. And my colleagues will publish an article about the future developments. And the fifth trend is the artificial intelligence entering the life of legal officials. And I do not try to say that I don't use it. I do. And we asked GPT chat regarding implementation of certain issues. There were two factual mistakes, for example, incorrect signatures. And GPT chat also added norms regarding duties. But the artificial intelligence also involves issues which we have not mentioned even, but it understands by analyzing that it is needed. So I really recommend to my colleagues, Arab Emirates, they launched the first neural system for the development of law. I do not call upon creation of similar system, and the human person is at the center. Yet I believe that it is a good tool which may provide assistance. Artificial intelligence is very interesting, but we have to return to the topic of efficiency of the EAEU law and what is lacking for its use by business community and states. Regarding the efficiency of law implementation, the EAEU law is must-have, and business usually does not see the international agreements, but only the decisions of the Commission. And you should ask more often Eurasian Economic Commission their opinions, and if something does not function, we will respond quicker. Why have I mentioned artificial intelligence? It's not because it writes laws, but it analyzes effects of laws that already exist and suggests to talk to the states and to change lacking parts when we talk about business. So we have a problem with checking. And when I was writing, I could write that, well, it is in line with the law. And the third, we need assistance. We have to see what is going wrong and not accumulate bad emotions from the business if something functions badly. Thank you.
Уважаемый Валерий Вацлавович,
Dear Valery Vaclavovich, there were discussions where the court is located. It is located in Minsk. How the legal community of Belarus lives under this reality and what directions can be defined. It's a very serious issue. Well, based on hospitality laws, since till the end of our session we have 3 minutes, I will dedicate time for the previous speakers. I will speak shortly. Taking into consideration that law understanding and law awareness is quite alive, if we see numbers, it is hard to see. Okay, I will try to be short. All the participants made amendments to their presentations. So, when we talk about the Republic of Belarus, and Belarusian lawyers, which are proud of it, it became a capital of the lawmaking, of justice, and in our country is the court of EAEU and the headquarters of CIS, and when we discussed the issue where the court should be located, the court of EAEU, I thought, well, I actually participated in this discussion, in this process, and other country offered to locate this extremely important body of the Eurasian Economic Commission in the Republic of Belarus, in Minsk, and due to the support of all member states, we today are proud to have the court be located in the capital of Republic of Belarus, in Minsk. And I also thought, based on the president's order, I was involved in locating it in a good location within the city center, in a good building. So we paid attention to each brick, and this historic mission was very important, and I also took part in this process. I believe that the court have taken place, and without the court, the efficient work would be impossible of the Eurasian Economic Commission, and functioning of the Eurasian Economic Union would be impossible as well. No important how we develop the norms and what kind of articles we write, but if there is nobody which can invisibly participate if something goes wrong and take necessary decisions and measures, if all the countries implement internal norms, they definitely take into consideration the norms and regulations of the Eurasian Economic Union. And here is the role of the court. Regarding the prospects of development, I believe that in the future we have to look at the practices, mediatory practices, and the Republic of Belarus actively implements different alternatives, ways of dispute resolution within our laws. And in May, the Ministry of Justice of the Republic of Belarus has signed a convention on establishment of international convention on mediation. And here I see many prospects and opportunities for all other countries. Well, I promised to be short. I don't want to say zero number. The court has a very important role and lots of prospects. We are glad to see you here. Thank you.
Владимир Владиславович, ну мы чуть позже начали, поэтому мы
пока
вроде как в графике, на самом деле. Поэтому один вопросик все-таки вам зададим такой, знаете, маленький совсем, да, все-таки Союз юристов, который вы возглавляете, такая,
Union of Lawyers is the main platform of legal community in Belarus, where new ideas and trends and work prospects are being discussed. Do you plan in the annual forum to cover EAEU topic? Yes, we plan. We have started 2 years ago, and we want to make this event a traditional one. At the beginning of December, we plan to conduct similar forum. We are discussing the EAEU topic, and I invite judges and secretariat of court to participate. in selection of topics and issues for the discussion. We will definitely find topical issues and qualified speakers to look at further details, the topical issues for today, for the Eurasian Economic Union and the space as well. When we talk about collaboration with associations, unions, lawyers of all member states of the EAEU, we are not doing well. Using this opportunity, I would like to suggest an association of lawyers. Well, you can call it whatever name you wish. An association of lawyers of Eurasian Economic Union's participants. Definitely there are professional unions of lawyers. In some countries, even a couple of them. In the Republic of Belarus, we have a union of lawyers which are united based on principle, in professional principle. It unites lawyers, prosecutors, judges. It unites all professions, and traditionally, I just came up with this interesting idea. Since we have here all the legislative bodies here in Minsk, we can also open a headquarters here in Minsk, and I'm sure that everybody will be glad to come here and to hold events here, but we can also hold events in the member states as well. So all the legal officials, they have to unite their efforts and contribute to other countries. Thank you.
Arjana Irjanovna,
finally, we came to you, and the topic is very important, and we talked about constitutional courts. How do you see the role of national courts? Maybe it's constitutional control in terms of integrational law. Do you see the potential for the court interaction between the member states? Thank you.
You cannot overestimate the role of constitutional courts. There are economic and integration processes underway, migration flows, application of AI, digitalization, creation of unified digital markets, etc. So the protection of rights and freedoms of people have become more and more relevant, so that's why the constitutional courts usually play a huge role. I would like to say a few words about the Constitutional Court of Kazakhstan. From January 4, 2023, we have relaunched the Constitutional Court of Kazakhstan, so in the understanding that usually exists. So we are the successors of the Constitutional Council of Kazakhstan. And since January 2023, apart from the applications of the President, members of the Parliament, and other officials, the Constitutional Court can receive applications from Prosecutor General, from the Human Rights Ombudsman, and from citizens. 99% of applications, around 10.5 thousand, is applications from our citizens on various matters. Mainly audit. They asked for the audit of the national legislation, whether it is in line with the Constitution. of Kazakhstan. With that, we need to note that international agreements and treaties ratified by Kazakhstan are part of our law, but there was a resolution of 2009 that all the international treaties of Kazakhstan can be recognized only in case that they take into account national interests of Kazakhstan. Constitutional Court of Kazakhstan in 2023, by the request of the Ministry of Trade, detailed this resolution, and they said that international treaties that do not protect national interests cannot be accepted or even considered. And if the treaties lack any protection mechanisms and arrangements, they are not taken into account. They can be part of the law. So the Constitutional Court of Kazakhstan can receive applications of citizens. As it said in the Constitution, it said citizens. It doesn't matter whether it is citizens of Kazakhstan, citizens of other countries, or stateless persons. So citizens can go to the Constitutional Court to check whether legislation or international treaties ratified by Kazakhstan are compliant with our constitution. But over 2.5 years of our work, we didn't have any precedents that treaties were not recognized as compliant. But there was an example of the Constitutional Court of the Russian Federation back in 2012, when two citizens of Kazakhstan applied to the Russian Constitutional Court. And the matter was that they were brought to criminal responsibility by the Russian legislation for transportation or smuggling of drugs as part of medication. And then the Constitutional Court of the Russian Federation issues a ruling to analyze the legislation of the Russian Federation and EAEU legislation. There were other cases as well, like 2022 case of tariffs. So I assume that there might be similar applications, and if they are, we will have to consider these applications based on the legislation of Kazakhstan and EAEU legislation. So, dear Ayjan, I have a small follow-up question to you. You mentioned that you have a new practice which is in place for 2.5 years when individuals can apply to the court. Currently, EAEU court does not have such competence to receive applications of individuals. However, there is a regulation when the Eurasian Economic Commission can make a ruling or decision with regard to individuals. Do you think individuals have chances to protect their rights in our court? Well, any individual should have access to justice. You know, court, including EAEU court, it's a judicial body. But this is up to the, treaty, to the agreement, the EU agreement. It depends what is written in the treaty. Countries should agree upon this. It's the lawmakers that decide. Well, citizens, like individuals, can apply to national courts, to constitutional courts, because legal entities cannot apply to a constitutional court, but they can go to national courts, for example. Thank you. Our session is coming to an end. I would like to thank all the speakers. I would like to thank the audience. Thank you for your interesting discussion. This session has shown that despite the problems that we have, despite the challenges that EAEU faces and we all face in this difficult international conditions, the law of EAEU is uniting us together and serves as a common language for us. Thank you.
Да, но при этом кажется, что дискуссия наша привела к тому, что нам надо еще больше работать и еще больше сотрудничать.
Well, our discussion has shown that we need to cooperate even closer and to work harder.
Спасибо, блестящие были.